Okay folks, let's get started. In this video topic for professional responsibility, we'll talk about the division of labor between the attorney and the client, or the allocation of decision-making authority. Now we've got a general principle here, a bumper sticker perhaps, and we say that the lawyer controls the means, and the client controls the ends. Now it turns out that that slogan doesn't answer all the questions. It's sometimes going to be hard to decide whether to slot a particular decision into the means category or the ends category, but it is some general guidance, and we'll practice with the general approach. Now, what do the model rules say about this? The relevant language, as you can see, shows up in Rule 1.2a, and there it does talk about the lawyer controlling the means by which the objectives are pursued, but the lawyer shall abide by the client's decisions about the objectives, even if the lawyer thinks that's stupid, maybe even that's self-destructive. You consult with your client, you point out what your advice is, but ultimately the client can overrule the lawyer on these questions of the objectives of the representation. The classic example of the client's control over a matter relates to settlement of litigation. So both in the criminal and the civil context, ultimately the client has to decide whether to accept or reject a possible plea bargain or settlement on the civil side. As a lawyer, you can give your advice about whether it's a good deal, but ultimately that is the client's call, even if the lawyer thinks it's a lousy deal that's being offered. Once the client has set the objectives, the attorney can carry out anything that's impliedly necessary to obtain those objectives. Obviously, it's got to be within the rules. The only obligation is that the attorney shall consult with the client about those means. So there's a famous example of this principle at work and just how tricky it is to apply. This is the long black veil story based on an old country song recorded over the years by different artists, Lefty Frizzell in the 50s, Johnny Cash in the 60s, Dave Matthews, I think, in the 90s recorded this, and what you're hearing now is Roseanne Cash, her version of this classic. At any rate, the basic story is a criminal defendant in a murder case instructs counsel that you can't go with an alibi defense here, because even though I'm charged with murdering somebody, and I know where I was, I can't tell anybody else where I was because I was in the arms of my best friend's wife. And so he's convicted, executed, and then the grieving former lover is seen roaming the hills in her long black veil. At any rate, notice here, the lawyer is supposed to control the means, and yet it's the client here who says, I instruct you not to use an alibi defense. The objective is acquittal. He wants to be acquitted. But he says, I'm going to take one means and place it off limits. You can't use an alibi defense. So even though it's means, the lawyer has consulted and is willing to go along with the client's choice, and it ends up resulting in conviction and ultimately an execution. So I don't think anybody would say the lawyer there did wrong, but it is an example of how the means-ends division is not always so neat. Now you do get some more clear-cut rules for a few things in the criminal context. So we do know under the model rules, and this is true in all the states, that the client's going to control which plea to enter and whether to waive a jury trial and whether to testify at trial. You just have to give the defendant the choice about whether to testify, again, even if you think it's a terrible idea, even if you know it's going to directly lead to the conviction of the defendant. That's a choice that the defendant has to make under the rules. There's also an interesting difference here between malpractice law and the disciplinary rules, because under malpractice law, the client can order an attorney to take a particular action, to employ a particular means, and if the attorney refuses to do so and it results in damages later, then it's no defense to say, hey, but I'm the lawyer and I control the means. This is, in malpractice law, just a method of establishing liability. We have an interesting application case here. It involves the interaction of this ethics doctrine of allocation of authority with the ineffective assistance of counsel doctrine. And the claim here by David Barnes, who's the defendant, is that the ineffective assistance of counsel doctrine should push more in the direction of client control. So the basic fact pattern here is that Barnes was charged with robbery and assault and larceny based on the victim Butts's identification of the assailant as Froggy. Well, Froggy was Barnes's nickname. And so he's convicted. Then on appeal, Froggy has several different theories for the appellate lawyer to pursue. And the appellate lawyer says yes to some of them and no to some of them. And so Barnes believes that that it was a mistake not to bring up some of his chosen theories when on appeal he lost. So later on he's challenging the effectiveness of appellate counsel. And the Supreme Court here says that we're going to embrace for Sixth Amendment ineffective assistance purposes, we're going to embrace the traditional allocation of authority under the ethics rules here. So it's okay that the lawyer listened, rejected some of the client's suggested means while consulting with the client about that, and there's no Sixth Amendment problem with that. Now that position does help appellate courts control their dockets. If we were willing to allow the clients to control which claims go forward, then you don't have that attorney acting as a screen for claims going to the appellate courts. Arguably, the clients benefit from having a mix of higher quality claims, even though a smaller number of claims going to the appellate court. Now, Justices Brennan and Marshall are dissenting here, and they want to emphasize client dignity and autonomy a bit more. They're not so much interested in how often is the client going to be right about the validity of that claim, but they want to promote client trust in a lawyer. And if the lawyer doesn't have to listen to the client, then the client may start to feel like, hey, I'm not in charge here, they're not really paying attention to me. So they're interested in coming at the lawyer-client relationship from a different angle, particularly for this group of clients who are inclined not to trust their lawyers and haven't had great experiences and so forth. There's also some concern in the criminal context that the defendant will believe that the lawyer is in league with the prosecutor and the judge. After all, in many cases, they're all paid by the same state. And so anything that you can do to promote the autonomy of the client and the client's control over the case will help resist this temptation to distrust the lawyer. But at any rate, the traditional allocation of authority is what the court ultimately endorsed in Jones v. Barnes. We'll be talking about other applications of this division of authority once we get together again. So see you then.